Criminal defense hero Don Hammond, Esquire. How are you today, sir?
Just fantastic, Jeff. Good afternoon. How are you?
I am downright succulent. Thank you for asking. The task before you today, I think, is rather formidable because I think the situation we're discussing is rather complex, and it would be complex even for those well-versed in the law profession, let alone laymen. Nonetheless, one of the reasons you are known as the criminal defense hero is because you recognize and you deliver as part of your job, making it digestible to the average person and cutting past the corned beef and getting straight to the cabbage. Or is it cutting past the cabbage and straight to the corned beef?
I'm not sure, but we'll try to make it digestible so the average person can understand the difference between these various charges and the monumental task that prosecutors have in front of them, as well as the certainly very serious situation that these former police officers are now facing.
That's right. And this podcast is not for emotionalists who are unable to grasp the importance of discussing nuances, that's what we're going to do, is we're going to analyze the law. We're not just because we see the subtleties or are struggling to understand the subtleties doesn't mean we approve of bad behavior.
I certainly very often preach about the differences between legality and morality, and seeing that there's a difference there is very important, and that the legal system does not always lead to a just or moral result.
So we are very much on the same page as far as that point is concerned. And those who can't handle it, go check out Vox or the Huffington Post or Daily Cause or something. This is not for you. So first of all, Don, I applaud you. Your prediction came out to be exactly what you said would be the case, which was that the third-degree murder charge would be changed to a second-degree murder charge. And I'm struggling to understand the logic of it all. In our previous podcast, we talked about an op-ed that Albert Goines and Lawrence Tribe wrote for the Boston Globe, in which they argued it should be second degree rather than third degree. And let me start by just struggling with my little layman's understanding, and then maybe you can jump in and tell me how much of this I'm getting right versus how much I'm not. I thought that their argument was basically the problem with third degree is that it applies to only unintentional killings and not intentional killings, and that one way it would not possibly be resulting in a conviction would be if there was evidence that it was intentional. And one of the advantages of second-degree murder is that it can apply to either intentional or unintentional killings. And the other problem was that there's case law in Minnesota which has ruled that the third degree tends to apply it's not just about whether there was intent to kill, it's about whether or not whatever happened was directed at a particular person. This is what I've been struggling with, and I think I have a new understanding. In other words, it would be like if somebody was shooting recklessly into a crowd and somebody got killed. Whereas with George Floyd, they may not have intentionally tried to kill him, but what they did was directed specifically at him, as opposed to just indiscriminately into a crowd. Am I somewhere near what's relevant?
Well, it sounds like you got this all wrapped up, so I'm going to go have a beer. Good work, Jeff. We'll catch you later.
Thanks for joining us, Don.
No, there's an awful lot to unpack there. And what is actually interesting to note that I think a lot of people are glossing over is that the third degree murder charge is still there on the new complaint. They didn't just upgrade it. They added a second degree murder charge, and they kept the third degree murder charge, and they kept the involuntary manslaughter charge. So now they added a charge rather than replacing anything. So all the theories are still on the table. The theory, I mean, you're absolutely correct about some of the issues with the third degree charge. Minnesota case law has made it pretty clear that that's for more of a situation where your aggression is directed at more than one person and then somebody ends up getting killed. So when you have a situation like this where, the aggression was obviously all delivered to one single person, it seems like the third degree murder charge probably is not appropriate. Now, there are alternative theories of second degree murder in Minnesota. So California doesn't even have third degree murder. So from a starting point there, we had to sort of figure out what the heck a third degree murder is for anybody who practices, outside of Minnesota, because that's not a very common thing to even have. The second degree murder can be charged as an intent murder, meaning that the prosecutor is alleging that the defendant had the intent to actually kill somebody. Or it can be charged as basically an unintentional killing in the process of committing a felony. And that's what they've charged here. The shorthand for it is felony murder. And an awful lot of states in this country have what's called a felony murder rule. California eliminated it a few years ago. So California no longer has the ability to charge somebody under this theory of the crime. The felony murder rule is generally applicable to situations where multiple individuals collaborate together to, go commit a robbery or some other crime, and one of them ends up killing somebody. It puts everybody on the hook for the murder, whether they intended the killing or not. So in this case, sorry, you want to interject something?
Well, you may be headed there anyway. I was going to say we have to analyze not only what the applicable statutes mean, but how the complaint is written up.
Right. So, I mean, the complaint is pretty clear that they are, and the Attorney General at his press conference was very clear that they're pursuing this under a felony murder theory. So what's interesting is that means they have to prove the predicate felony. In this case, a felony assault. That is controversial to say that the police committed an assault here. I certainly think that they went beyond the scope of what they're supposed to do as police officers. And I think that, they're certainly culpable for killing this guy legally. But it's tough. It's a tough message to send to police officers that they could be charged with assault in similar situations. If the person didn't die, it's sort of a where's the line. Well, I'm not saying that it's wrong here. I just think it's an uphill battle for prosecutors.
Well, I think that's what Andy McCarthy's point is. And we should also mention that the case has been taken over by Attorney General Keith Ellison, who has a reputation as being a bit of a radical activist. And McCarthy is saying that the way he reads this is that Ellison was motivated by changing the charges to whatever would be more palatable to the public. And, in other words, second degree sounds worse than third degree, and this tends to calm people down. And he was making the point, what you just made, but he made it a little bit more forcefully, that he thinks it's absolutely wrong to set it up so that the restraint of Floyd was itself illegal from the beginning. Can you say a little bit more about that part of it?
Yeah, it's a tough message to send to police officers. I think that it was. I think that here in this situation, they had him already in handcuffs. He's on the ground. There's certainly no reason to continue trying to restrain him, especially with a knee on the neck. That's the one that really has everybody outraged, and that's really, the crux of the issue. The other officers with a knee on his back and, on his feet, that's, I think, less of a concern. And we'll, of course, get to the fact that they're also charged with aiding and abetting a, felony murder, which is the legal chain to get there gets even more complicated,
right.
Let alone aiding and abetting a manslaughter, which is a fascinating legal concept.
which was another one of McCarthy's points, which is that he says it's a non sequitur to say, on one hand, it was an unintentional killing, and these guys were aiding and abetting. What were they aiding and abetting? Something that was unintentional? Which is not to say they should be let off. He said they should have been charged as the lead officer was.
Well, they should be charged with their own assault, if anything. Aiding and abetting is a tough. So to be guilty of aiding and abetting, they have to have the intent to assist, or the intent that the lead defendant accomplish his objective. So we're talking about he's charged basically with an assault, which then is the predicate for a felony murder. So they would have to share the intent to commit a felony assault, and that's tough when they're not, doing anything that would have led to a killing. They're doing what looks to me to be much better police work than Chauvin was. Certainly they had a moral obligation, as I said before, to stop him, to tell him, hey, knock it off, this is not appropriate. They didn't do that. Legally, is that a crime? That's a tough question, because nobody has an obligation to stop another person from committing a crime legally. Morally, that's a different issue. But legally, we don't have an obligation as American citizens to stop somebody else from committing a crime that we didn't really have a part in and didn't have an intent that they carry it out. So if they're doing, if I'm doing good police work with my knee in somebody's back, holding them there for backup to come or for the paramedics to come or whatever, I don't have that's what I'm doing. And that would not have led to a serious injury. To then say that I had the intent for my fellow officer to, kill somebody or to commit that egregious felony assault, that I think it's a stretch.
Yeah, well, especially since the claim isn't that the lead officer intended to kill him. It's that it was unintentional result of an intentional assault.
An intentional felony assault. And not all assaults are felonies. So you'd have to dig into that. I mean, a simple assault generally is a misdemeanor.
We should mention the other officers' names, and I haven't heard them said out loud, so I don't know if I'm pronouncing it correctly. Derek Chauvin is the one who had his knee on the neck. J. Alexander Kung, Keung, is one of them. Thomas Lane, I'm pretty sure I'm pronouncing that correctly. And then the other officer, first name Tou, last name Thao. I guess that's Thao. Now, I read the complaint, and there is nothing in there that describes what was bad behavior on the part of Thao. And this is something I've noticed before. I don't know how common this is. I want to ask you about this, and it's infuriating to me, and I'm wondering if there's any excuse for it. In the George Zimmerman Trayvon Martin case, the behavior described in the criminal complaint wasn't a description of a crime. So it just seems to me inherently wrong and outrageous to make defendants go to trial without telling them what it is, if proved, would be the crime. I understand that all the evidence comes during the trial, not at the time of indictment, but it seems to me at the time of indictment, it should be clear what it is that might be a crime, if proved. And in the George Zimmerman case, they said he was following Trayvon Martin. He called the police, and it's like, yeah, so they didn't say, well, he used excessive force, or he pulled a gun on him, or something or other that would have been the crime. And so here again, I'm not a guy who's familiar with a lot of different police complaints, so I only have that one example in my mind. But here again, this guy Thao isn't accused of anything that, if proved, would be a crime. What's up with that, Don?
Sure. That particular officer, Thao, is hardly even mentioned in the probable cause statement that accompanies the complaint. And it's tough to imagine. I mean, I think morally, he should have told Chauvin to knock it off and get off of the guy. Legally, I don't think he has an obligation to do that. And he's standing there doing crowd control. It's really tough to believe that he would bear criminal legal liability in that situation. and to believe that he would have harbored the same intent to commit a felonious assault against Floyd in that situation. That's going to be the hardest one to prove out of all of them. It is common, and it varies by state, certainly, as to what they have to include. And there are things defense attorneys can do to try to get a more particular statement. I've had cases where I've filed a demurrer to the complaint because I feel like there's nothing stated in the four corners of the complaint to tell me exactly what they believe the criminal conduct was. It happens in vehicular manslaughter cases where all they'll do oftentimes in California is parrot the statute. We allege that, Sam Smith committed X crime by doing, quote, exactly what the statute says, and that's it. They give no details. They may give a date, but they give no details. And, when the statute...
You're saying it's common, and you're saying that you file, what'd you call a demurrer?
Demurrer.
A demurrer. And does that normally clear it up? Because, like in the Zimmerman case, that was never cleared up. They went to trial based on him following Trayvon Martin. Now, following could only means, if you just go with the literal meaning of the word, means that you were behind a person, perhaps 3 miles behind them, perhaps 2 inches behind, perhaps you were running, perhaps you were walking. There's nothing criminal about being behind another person and moving towards them. And that was never cleared up. So shouldn't that be grounds just to toss it out? I mean, it's not that I have any particular feelings about Trayvon Martin or George Zimmerman. This is on principle. The defendant should know what it is that the state is accusing as being criminal behavior.
Yeah, the defendant should absolutely be put on notice of what it is that the government believes was the criminal act. With respect to Chauvin, I think it's obvious that they're saying the criminal act was keeping your knee on his neck for 8 minutes, and that was well beyond the scope of anything that you're supposed to be doing or trained to be doing as a police officer, and that in fact was a criminal assault. And when it leads to death, that becomes a second-degree felony murder. With respect to the aiders and abettors, I mean, it's that the theory has to be that they harbored the same intent to commit that felony assault. And certainly with regard to Thao, I think that's difficult to show. And the others, it's probably a better case against them than it is against Thao, but it's still tough. Again, we're trying to get inside people's heads. The reason, I think that charging it as a felony murder is kind of a chicken shit move on the part of prosecutors, because it relieves them of having to prove an intent to kill, which is what I think people expect when they're charged with murder. That's why states like California have eliminated the felony murder rule. If you didn't intend to kill somebody, you're not going to be convicted of murder in California. There may be a few other nuances to that, but that's the way that the law works. So, I think they should charge him. If they're going to charge him, they should charge him with the intent. Right. So, or charge him with just the manslaughter. I think there's a very good chance that what we're going to end up with in the end here is a manslaughter conviction.
And just paraphrase or summarize what the manslaughter charge means in Minnesota.
So it's a criminally negligent homicide. So they recognized but disregarded a risk of serious injury or death. So that's certainly a step removed from intending that serious injury or death happen. They knew that there was a risk and they disregarded that risk, and then it came to pass, and that's a negligent homicide, which is manslaughter. Right.
Now, McCarthy is saying that the way the original complaint was worded and with the third degree charge, what they were saying was that it was okay to restrain the Floyd, but the manner in which he was restrained was unlawful. And McCarthy is saying, well, now the allegation is it wasn't even okay to restrain him. Is that the way you understand the allegation?
I think McCarthy has taken that a little far. I mean, he's basing that on like a few words that were apparently changed or deleted in between the two drafts of the complaint.
Yeah, I agree. They kind of downplayed the allegation that Floyd was resisting, and McCarthy's acting like nothing at all was said. But I read the complaint.
It's in there.
Yes, I noticed that too. So let's not forget that the cops showed up because it was reported a counterfeit bill was passed. And they, at least according to the complaint, and no reason to doubt it, I suppose, the cops, or one of the cops, immediately pulled a gun on Floyd and said he was being arrested for passing a counterfeit bill. Is that normal police behavior for this type of crime, or would it be more like, let's talk to the person and allow for the possibility they didn't even realize it was a counterfeit bill?
No, I think it's a gross overreaction to the situation from the very beginning. I am positive that if I printed 100 fake $20 bills off of my printer at the office here and, went to 100 different liquor stores with them, and 100 different clerks realized that they were counterfeit and called the police, which is dubious, I am positive that 0 of those times would I be placed in handcuffs. That's just not the way that things should be done. It's not good police work. To my knowledge, I mean, I still have not seen this $20 bill, any photo of it, any evidence that it's been recovered. I've seen nothing to indicate that the police have made any effort to even determine whether that was a real $20 bill or not, let alone whether Mr. Floyd would have known that it was counterfeit. So, I mean, there's no underlying crime here as far as I'm concerned. The police have done nothing to demonstrate that there was even an underlying crime to warrant their involvement, let alone their gross overreaction.
Yeah, and as far as morally or just common sense, that seems obvious. As far as the law is concerned, how relevant is that they began? In other words, does that indicate criminal culpability or tend to lean in that direction? That this whole thing started by them overreacting to something that may not have even been a crime?
Well, if I were a prosecutor, I would make a big deal out of that in the case, that they came in here with a mindset that was inappropriate to the situation to begin with.
Yeah.
It's not strictly relevant. As a defense attorney, I would fight to keep all of that out because it's not relevant to whether they intended to assault him, or maybe it is, but I would make that argument certainly, and try to, keep people from bringing that kind of stuff up, because it's not strictly on point to, the knee in the neck and what ultimately, would be the assault that the government's trying to prove and the murder that would flow from that. And we're talking about a $20 bill. This is at most a $20 crime. We don't know what he was trying to buy with it, but maybe he would get change and whatever. So it's a $20 crime.
Right. I mean, it's not like it was a $50 bill, which would have, justified shooting him in the head, of course, but it's only $20 bill.
Yeah. Well, in California, anything under 950 you're in misdemeanor territory. So, we're a far cry, and this would be a cite out misdemeanor. Nobody goes into custody for this kind of a charge. You write him a citation, say up here, give me the $20 bill. Okay, cool. Maybe it's fake. Maybe it's not. Here's your citation, and come to court 3 months from now. See ya. Have a nice day. That's the way this goes.
Let's explain to people that what your reference means to that 900 and change thing. People who know about that law, meaning shoplifters, they go into stores with calculators, knowing that nothing will happen to them as long as it doesn't total up to, what is it, $950 or something?
Well, I've never had a client who actually did that. I think that's probably pretty rare. But if you're saying that you have anecdotal evidence that you and your friends do that, then I'll take you at your word.
Okay, yeah, I was saying something like that. What about the body cam issue? As I read the complaint, I think it mentioned 2 of the officers had them, and I don't think it said that the other 2 did not, but the implication is they did not. What do you know about that?
Well, so you can see on the video that it appears Derek Chauvin did not have a body camera, which is fascinating. I don't really know what Minneapolis PD's body cam policy is. As to whether every officer is supposed to have it on all the time, like some departments are. But the complaint does reference body camera being available from at least 2 of the officers on scene, and one body camera has actually been released from another officer who wasn't actually involved in the scuffle. So I've seen that footage. It's heavily redacted. But at some point, we'll presumably get to see all of the body camera from every officer who had one on scene. And body cameras, I think, are huge and very important for everybody involved in the criminal justice system. As a defense attorney, I really enjoy seeing it, no matter what it proves. I mean, there are cases where I get the body cam and it's like, yeah, this really shows that you screwed up, dude. And then I can show that to my client and say, I don't know, is this, if the jury sees this video, ultimately, what are they going to think? Maybe we should resolve this case. And there are other cases where the footage tends to exonerate my client, or it tends to show that the police, had a biased investigation and didn't do things right. And we can make a lot of headway with that.
Yeah. I mean, I don't know what the downside is other than cost. And I don't know how bulky or uncomfortable it is to wear, but there seems to be a very big upside to it. And I'm wondering, well, what would be the reason two of the officers had them and two didn't? And I'm thinking to myself, maybe limited funds, they can't afford everyone to do it, or maybe it's optional, or maybe it's required, but two of the officers failed to meet their requirement. What do you? The
department would have some policy regarding use of body cameras. I suspect that it may have more to do with the type of enforcement work those officers are assigned to. Patrol officers are going to be more likely to have body cameras than detectives often will not have body cameras. If he's assigned to some detail that has some specific purpose where he's not usually out on patrol, that would explain why he doesn't have that. I saw some speculation that he might have been relegated to some sort of a park police assignment based on some of his prior record. I have nothing to back that up other than speculation. But if he's on some sort of a different detail than normal patrol, that would explain why he in particular didn't have a body camera.
Right. So your position, I think, is that as a matter of policy, it should be a priority to require everybody that's out in the field to wear these body cams and find the money somewhere. Is that?
Absolutely. Absolutely. And there's a lot of variation, certainly across the country. I mean, with the departments I work with, it baffles me. LAPD, body cams on every officer. Sheriffs, very few body cameras. It's rare for me to get it. Highway Patrol, they have dashboard cameras in their vehicles, no body cameras. A lot of local police departments like Torrance and Redondo, body cams on every officer. Palos Verdes Police Department, one of the richest areas, no body cameras, no dashboard cameras, no video anywhere. It's really baffling to me.
Yeah, I think, Black Lives Matter isn't known for their clarity and for making good, solid, doable demands that could reasonably be met. That might be a good demand, Let's make it mandatory for all cops out in the field to wear body cams. That would,
it goes further than that. I mean, to require them to have them on during all investigatory or, subject contact would be important.
Okay, when it matters, let's say, I don't know offhand everything that police do in the course of their profession. If somebody's in an office all by themselves and they're not interacting with any,
I don't need them to have the body camera on when they go to the restroom. Although I have gotten body camera footage that includes that if it's during the course of an investigation.
Excellent. Well, next episode, let's post that.
Yeah, sure. I'll be sure to pull that footage for you.
All right. So speaking of Black Lives Matter and their supporters, let's irritate that crowd a little bit by digging into the evidence with an eye toward assessing what possible defenses could be raised. And again, this doesn't mean we approve of the behavior. It means that this is relevant in terms of determining guilt and what punishment is and how well the allegation matches the text and meaning of the law. So Floyd, had various drugs in his system, including fentanyl, I think a rather large dose, and he had foam coming out of his mouth, according to the complaint. Is it relevant that the police are trained, and how are they trained, as if you know, to subdue a suspect who is behaving as if they were under the influence of such substances?
So there's a lot of variation in drug recognition training amongst officers. There's a relatively short time period spent on that in the academy, which I know. I've actually attended the LA County Sheriff's Academy, and I've interviewed many, many officers about their drug recognition qualifications. There are, outside of the academy, there are 7 different classes that officers can take that are sponsored by NHTSA, the National Highway Traffic Safety Administration, as well as the International Association of Chiefs of Police. So officers have all varying degrees, and actually those white notebooks that you see on the shelf behind me are the training manuals that go with a lot of those drug recognition classes that officers can take. But I think the question was more specific about the tactics of restraining someone. And, that is, I mean, you're told that you can use whatever amount of force is necessary, and that's legally true. You can use the amount of force necessary to overcome the resistance, to effect the arrest. At this point where somebody's already in cuffs and they're on the ground, what amount of force is necessary to overcome the resistance? None. You could,
right.
you could get up, you could let go of him completely and walk away. He's still laying there in handcuffs.
Well, it's more than that. Again, I'm not making the argument. I'm just mentioning what happened and asking to what degree is it relevant. Now, there was a point in the recording of the original incident where we hear 2 of the officers discussing what is the proper position to put the detainee's body in. Should it be on his side? Should it be on his back? It seems to me, again, is that not relevant in terms of establishing whether there was intent to kill? Doesn't that suggest the opposite?
Sure, it'll absolutely be used in defense of those officers that they were asking the questions and that they were shot down, that they did not. They will have to be arguing that they did not share Derek's intent to commit an assault, and. That will be evidenced by their questions about, hey, maybe we should stop this. Maybe we should turn them a different way. Maybe we should do something else in this situation. And that's going to be a key part of their defense.
But I think it also helps Chauvin, I think, because he didn't say, no, who cares? What he said was, no, this is the appropriate way. I mean, I'm paraphrasing, but that was the essence of it, right? I mean,
he will undoubtedly bring in, he will find and pay, which happens. That doesn't mean they're wrong, but he will find and pay a police practices expert to analyze that video and testify on his behalf that what he was doing was absolutely appropriate.
Or that thought it was. In other words, there's an argument to be made that it was more stupidity than it was malicious intent. I'm not making the argument. I'm telling you there is that argument that will be made. Does that not seem plausible to you, Don?
Ultimately, that's a question for a jury. But yeah, the dumb card works sometimes. I've certainly had clients who have just been stupid with no criminal intent, and we're actually usually able to get pretty good results in those cases. Because, we don't, especially for lower level things, somebody's already learned their lesson. They're going to move on with their life. And, they've learned not to do this stupid thing again. Yeah. Okay. Let's all move on. When somebody's dead, that's a whole different situation. I think stupidity doesn't necessarily get you off the hook for a murder. But when it's charged in this chicken shit way of the felony murder, where, now the government has to prove that he intended to commit an assault, felony assault, that then led to a death. As a defense attorney, I'm going to throw everything against the wall. Absolutely. I'm going to say, no, there was no intent to commit an assault. He was following his training to the best that he could remember it at the time in this very stressful situation. And for a jury to come in here and Monday morning quarterback the hard work that these officers are doing out in the field is just ridiculous. They should be given very wide latitude. I think he should be convicted of something. Absolutely. But
yeah.
I would be obligated to make those arguments.
Another factor that I suspect is relevant that I haven't heard many people mention is the degree of pressure on the neck and what the video does or doesn't tell us. Obviously, I'm not saying this was the case, but obviously, if a neck is simply touched lightly, that's not necessarily going to be harmful. And it depends what part of the neck, and it depends how hard the pressure was, and it depends what the duration is. In wrestling, people put their opponents in holds where the arm is touching and going around the neck. Is that going to be a factor? And how revealing does it look to you on the video as far as where on the neck, the degree of pressure, and for how long?
I think it absolutely looks inappropriate. But what's going to be relevant there legally is they're going to dig into his background and whatever training he's ever had. And he was a security guard at one point, so they'll look at whatever training he had at that point. If he's ever had any martial arts training or MMA or anything like that, people will dig into that training and see what techniques are taught and what he would have been told about the dangers of constricting not only airflow but blood flow to the brain. They'll certainly look at his academy training and maybe call in academy instructors from his class to talk about what their curriculum was. They'll certainly bring in the training manuals from his academy class to look at what he was told about those kinds of things. All of that's going to be incredibly relevant to, whether he thought he was doing the right thing.
And then there's the medical examiner's report, which says he did not die from asphyxiation. And the fact that he was able to say, I can't breathe, and this and that. And I guess when the neck is being held in such a way, at some point, sometimes you can't even talk. And again, I'm not making excuses for it, but I don't think you really answered my question, Don. So let me try again. Can you see on the video what the degree of pressure is? You said that it's inappropriate, but do you think that's revealing on the video? Or is it grainy enough, or whatever the word is, so that conceivably the defense could argue in a way that might actually work? Well, you haven't proved the degree of pressure. We don't see it. We hear the guy talking. His arm was near the neck or on it. So tell us about the degree of pressure.
Well, we'll have to look at all of the different angles of videos that will be available. There's certainly that one, bypassers video. There are a couple of, at least two different bypassers now I think I've seen, and we'll have to look at all the body cams from these different officers and really, see what we can tell. And each side, one or both sides may bring in an expert to testify about exactly that, what they see, and what the vascular structure is inside the neck and what it would be constricting and how much pressure that takes. I mean, it doesn't take a lot of pressure to constrict, a vein or an artery in the neck. It takes very little pressure to do that. So no, I can't tell from looking at it, and I'm not a medical expert. These are the kinds of situations where we hire experts to come in and testify about those kinds of things.
Right. Well, again, we're not excusing the behavior. We're talking about what evidence is relevant and what is or isn't likely to result in a conviction. Now, the majority of people, especially when it's, a very controversial case that's aroused a lot of passions, the majority of people totally fail to consider all these kinds of details. And they just, are simply, there's a lot of people who are simply lusting for punishment. And so that's why this is important, because he may not be convicted, or he may not be convicted of what, the public craves. And
sure, I've seen people interviewed, out at protests who say they would settle for nothing less than a first-degree murder. And it's clear to me that people saying that have zero concept of what a first-degree murder is and what it takes to prove that. But people just don't understand. And you can't expect them to, right? I mean, everybody has their own role in society. They have their own jobs. They have their own things. And one of mine happens to be defending people who are accused of crimes. So, I think, the average person, I don't expect the average mortgage broker to be able to tell you the difference between first, second, or third degree murder.
Well, I agree halfway with what you said. And the part I agree with is that you can't expect them to have your expertise, but they should realize they don't have the expertise of a lawyer and tailor their comments accordingly. Instead, we're plagued with a nation of emotionalists who pretend they know what they're talking about and create problems. And
Well, that would be nice. One of the favorite things that I saw, I think, at the beginning of the coronavirus pandemic was a Facebook item or meme saying that that's funny. All my friends who were constitutional scholars last week are now, viral disease experts this week.
yeah, right.
And now all those same people are somehow legal scholars regarding police misconduct scholars, use of force scholars, legal charging scholars. I mean, these people managed to get a lot of education in very short time periods.
Right. And they're not only scholars about the law in general, but sometimes the most obscure issues that even lawyers wouldn't know about. What's that clause in the Constitution about the president's not supposed to accept gifts? What's that word?
The emoluments clause.
Yeah, the emoluments clause. I think I just demonstrated most people aren't even familiar with the word emoluments, but when it comes to Trump, suddenly they're experts on how to interpret that. And the 25th Amendment and treason and, what's the other one? The law that prohibits negotiating on behalf of the United States. It's like never been enforced. You know what I'm talking about? I can't think of the name.
I'm vaguely familiar with that one. I don't pretend to have memorized the entire Constitution.
No, these are just examples of what the Twitter lawyers claim they know. It's so ridiculous.
Legal expertise in 142 characters.
So we are now. I don't know. It's hard to know exactly where we are in the whole spectrum, but I guess we're past the peak of the worst of the riots, but there are still some demonstrations and obviously the potential for more, and it will likely be pegged to how this case is carried out in Minnesota. I don't know if you're in a position to speculate what public reaction will be, but can you give us a little insight about what the process will be as far as the justice system is concerned in Minnesota, and a little bit of a timetable?
Yeah, we're certainly a long way from any kind of convictions or acquittals. A serious case like this can take easily a year, often 2 years or more, before it's actually resolved. The first step would be, an arraignment. I haven't actually seen anybody be arraigned yet, and I imagine the news will cover that pretty openly. At an arraignment, I would expect them to enter a plea of not guilty. And then generally in a felony case, the next step would be a preliminary hearing. And there may be a couple of, status conferences and things before that even happens, where attorneys are exchanging discovery and figuring out if they can try to resolve the case at an early stage. I don't expect this case to be resolved in an early stage, but the defense attorney may file some motions, like Mr. Thau's attorney may file a demurrer or a motion for a bill of particulars or something along those lines to try to get, a better statement of what exactly their theory is that he did wrong. That could happen at a very early stage of the case, and it could delay a preliminary hearing for a few months. At a preliminary hearing, the government would have to put on sufficient evidence to convince a judge that there's probable cause to believe a crime was committed and that these people committed it. Then they would be held over for trial. Then you have multiple pretrial appearances. I would be shocked if this case were to be resolved within the next year.
Right. Well, as you were, thank you for painting that very vivid picture. You did a great job. And as you were going through that list, I was trying to imagine with each of the examples you gave, what might set the public off, provoke controversy, whether it's to the point of riots or not, but just provoke controversy. I guess it's hard to predict. In the case of Thau, I had no idea what he did or didn't do. And I have no reason to root for or against him or root for or against anyone or anything, except that I'm just outraged by the notion of anybody being charged with a crime and not having it described what that person supposedly did that, if proved, would result in a conviction. And I know you answered me. I still don't have a clear idea of how often that happens. You said you can file a demur. Am I pronouncing it correctly? Demur?
Yeah. Well, and there may be other types of motions that serve that purpose in Minnesota.
Right. But can you,
some judges will grant that kind of a thing, and some judges will say, nah, that's fine for this point.
Yeah. It just seems so obvious to me. I guess I shouldn't expect everybody to think exactly the same way I do, but
I'm not sure anybody thinks exactly the same way you do.
Yeah, and that's probably a good thing. But it just seems, based on common sense, basic fairness, it just seems so obvious that it's like rape, what was, when and where did it happen? It's like you go to trial. Bank robbery, you don't say when it happened or who did it. You kind of, if people are charged with bank robbery, you say, well, it's because the guy went up to the window and he handed a note saying, give me all your money. And, that's whether or not the person did it, that's what would be the crime if he did it. You don't just say bank robbery. So I don't know why you just say aiding and abetting. Okay, let's go to trial.
I've got complaints against clients that say things like that have ors in them, that he either negligently or intentionally committed an act that would be a crime, or did some other act that a person with reasonably prudent care wouldn't do, and that's it. And I'm like, so what act are you alleging that he did or didn't do, or that he intended or that he didn't intend? What are we talking about here?
Right.
And it's absurd to me. And sometimes judges tell me, go pound sand. That's enough. They quoted the statute. And I'm like, what? What are you alleging was the actual conduct at issue?
There are law professors and activists who are committed to what we might broadly call justice reform. And within the people who focus on the issue of justice reform, is my little pet peeve here something that has come up very much, or is this more like a Jeff Norman pet peeve that, I'm one of the only people who's immensely annoyed by this?
I very rarely hear anybody talking about it. I mean, on some of my defense lawyer listservs, it comes up occasionally when we're talking about things like demurrers or, exchanging sample motions like we do. We say, hey, I have a situation here where the prosecutors failed to, give us notice of what exactly they think the problem is. And, so we'll file the appropriate motion. That doesn't mean a judge is going to grant it. Usually we have some idea. The case I'm thinking of, my guy made a left turn that I guess the government is alleging is the problem. But are they alleging that left turn was in violation of some law, or that it was just negligent, or what? Unfortunately, a driver in the other vehicle ended up dying. That's why I'm in this situation. But it's crazy.
So as far as other issues to discuss, not today, but in subsequent podcasts, I'm wondering if anything has caught your attention. I'll tell you, I haven't looked into it that much yet, but one issue that is interesting to me is that the ACLU has filed several lawsuits, including one about the trouble that broke out in Lafayette Park the other day when, just before Trump took his walk to the church, officers cleared the park in a manner that has resulted in some controversy. Sure. And the ACLU has filed a lawsuit saying that the protesters had their rights deprived. And I think that would be very interesting. Have you heard very much about that, or are there any other issues?
I've looked at it. It looks like there's some disagreement about how they were cleared out and what their purpose was in being there. So, I'd be fascinated to see any footage about it. It's certainly something we can talk about. I take issue with the government apparently calling people liars because the people said they were attacked with tear gas, and the government says, no, those were pepper balls. You're full of shit. Well, does the average person actually know the difference? Come on. Let's not split that hair.
Well, whether or not, or who we're to blame for the hair splitting, maybe we should start with who's making the accusation. So, in other words, if there are people who have chosen to make an issue out of it, in other words, if their beef is that what makes it wrong, or one of the things that makes it wrong is that it's tear gas, then it's perfectly fair to respond. You can't blame people who have responded to what the accuser said when the accusers are the one who made an issue out of it. I mean, isn't that the complaint? Oh, they shouldn't have used tear gas. Well, if it wasn't tear gas, then what is your complaint?
Well, now the complaint is they shouldn't have used pepper balls. Now that we know the difference, but to call them, to impugn these people for not knowing the difference on the ground is I think pretty callous.
All right. Well, it might be more a matter of semantics than who's got a beef and who doesn't. So I would like to know, well, first of all, what happened. What was the basis for the police action? I got into a prolonged debate with Scott Ritter, who was a previous guest with us here on the podcast. At least one, maybe both of his daughters were there. And the argument they're making is their First Amendment rights were violated because they were entitled to peacefully protest. And I'm saying, well, I don't know how peaceful all the protesters were, but there is no First Amendment right to protest without a permit, correct?
I'm not sure a permit is always required, but protests and First Amendment speech are subject to reasonable time, place, and manner restrictions. So
Right.
The government can impose some restrictions on how that goes down. Certainly the optics are not good when, the president wants to go have a photo op at a church. And now you're going to go clear a bunch of people out who they say they were peaceful and they say that they had a medic station set up there on the church. I don't know. I wasn't there. I haven't seen video. It's tough to know, but the optics are not good.
Well, I feel it was not my intent. I was just mentioning it as a possible topic. I feel that we've now started to debate and discuss it, and it's okay with me if we continue, if it is with you. Yeah?
I'm okay. I mean, I think that we might catch more people who are actually interested in it if we label something that's what we're going to talk about.
Right. Well, we can do both because by the time we get to it in a way that has been promoted, there'll probably be more evidence that has come out. Sure. But let me just try to lay out what I think is relevant. So one issue you mentioned is that the demonstrators were allegedly peaceful, or they may not need a permit. Now, the other thing is what is the reason that the police are given? The police say that they had bottles and rocks and so forth, objects thrown at them, and they were responding to that. So let's see the videotape. It doesn't seem unreasonable if they were assaulted that they would take some action along the lines of clearing the park. Also,
wouldn't it be great if all those officers had body cams?
Yeah, right.
Well, but I bet that whole area is covered by government surveillance cameras from the church, from the White House, from all the monuments in the area. I mean, that whole area is covered with cameras. We shouldn't have to debate the facts here. We should be able to watch the footage and then talk about what was appropriate.
By the next time we talk, we'll probably see some footage, and then of course everybody on their cell phones. So there should be some footage.
Of course, if the government declines to release the footage, that may be an issue in its own.
Well, the government can't do anything about everybody who has cell phones, so something should come out. Now, the other thing is, it was about a half an hour before curfew, so I don't know whether or not. Of course, it matters what the government is even claiming. You can't be a good excuse if the government isn't even claiming it. But it seems to me if they were to say it was to enforce the curfew, Is that reasonable? Even though the curfew started was set to start at 7, and this happened at around 6:30. Could the police position be, well, it wasn't 7 yet, but as soon as the clock hits 7, you can't instantly be home. So we want people to start leaving so they could be off the streets by 7. Would that be a reasonable
No.
of law enforcement? No, it would not.
I think that's nonsense. I think if you tell people a time that they can no longer be out there, then you have to give them until that time, because that's going to be their assumption. You've set up the expectation that I can be here until 7. You don't get to come in with force and remove me before that, unless I'm being violent or violating some other law.
Right.
All these curfews are going to be very fascinating. I'm actually excited to be meeting with a couple of people next week on these curfew issues, people who have received curfew and protesting tickets, to see exactly what the circumstances were. Now, and in that particular situation in Lafayette Park, I'm not aware of anybody actually having been arrested or cited for any of that. They were just cleared out with force, and then
that's
sent
what
on
I
their merry
mean.
way.
Yeah, that's what I mean. I wanted to make that point. I shouldn't be making excuses for the government if they aren't even making that claim. But you never know what might come out that I'm not aware of yet. So, but this could be an issue in other cases too. So it's worth talking about. So you're saying it's not reasonable to enforce a curfew half an hour before it starts. But what about 7:01? Couldn't the claim be, well, it's not reasonable to enforce it at 7:01 because we need time to get home? So when can they enforce it? Can they enforce it at 7:01?
At 7:01, people should be making efforts. They should hopefully already be cleaned up. But at a minimum, if I'm a reasonable officer watching this situation and nobody's being violent and they're cleaning up their stuff to leave at 7:01, okay, I'm not going to come in with pepper balls and smoke grenades and, a show of force. They're cleaning up their stuff and they're leaving. All right, cool. Situation over. There's no reason to use any force at that point.
Okay, good point. And then the other thing you said reflects a little bit of anti-Trump bias, in my opinion. Your reference to clearing the park for a photo op. This is one of the accusations that's been thrown around a lot. And my reply to that is, well, anything's a photo op. You can't call something a photo op as if there's something inherently bad about a photo op. The president and many politicians make appearances, and they're often for photo ops. So what? Is it not legitimate to clear the public away from the president of the United States when he's making an appearance? Now, we can argue about the manner in which they were clearing, but just the idea of having some distance between an audience and some police between the audience and the president, isn't that rather normal? Whether or not it's a
you usually have advanced notice, and you have a clearance process that prevents people from coming into the area for some time period before.
Yeah.
You're going to ask people to move if they're there. You're not just what I understand the situation to be is they went in, basically, non-lethal force, but guns blazing, to clear these people out without really asking. I think that the typical routine would be for some sort of a Secret Service person to go over to the church, approach the pastor and say, hey, the president is going to be coming over here, tomorrow or 2 hours from now, hopefully not, but maybe 20 minutes from now even, and say, hey, this is what's going to be happening. We're going to need to clear out this area. This is the situation. I've seen no evidence that happened.
Well, I don't know if you've seen any evidence at all. I know I haven't, but I know that the ACLU is making that allegation, which was that there was inadequate notice. And I also know that the police released a statement claiming that after they were assaulted with rocks and so forth, they made, I think they said 3 announcements through a loudspeaker. I'm not sure what the period of time was. And so
how clear that was, the audio quality and whether it was actually audible. And, there are a lot of variables there.
Yeah. So we agree that is all relevant. We're not sure exactly, but that's relevant. Now, the other thing the ACLU is alleging is that the enforcement was based on viewpoint discrimination, meaning they took that action because of what position the protesters were taking. And I think if the evidence supports that allegation, then the government should lose, because it is unconstitutional to subject people to viewpoint discrimination. But I'm going to predict the evidence is very weak in that regard. Any thoughts about that, Donald?
Yeah, I think that's a tough case to make when you have a blanket curfew in an effort to clear everybody out of a particular area. I mean, it's no secret probably as to what, political viewpoint or, social progress viewpoint those people had, but that doesn't mean that you're clearing them out because of that.
Right.
Absolutely. If you can show the government cleared them out because of that viewpoint, then yeah, the government is hosed. But I think that's a tough argument when you have, a curfew is content neutral. We want nobody out here. An order to clear an area is content neutral, and I think I think we probably agree there.
Yeah. In fact, I think the ACLU complaint is laughable. They, a once great organization, has now turned into an anti-Trump group, and it's getting them a lot of donations from all the anti-Trump people, but they are no longer a principled organization. We need another group that has the same mission as the ACLU to conduct itself without their anti-Trump bias. Badly needed in this country.
And principled politicians are also badly needed.
Yes. And also a lot of things are needed. All right, Don. Thank you for that. That was not planned. Thanks for just going with my stream of consciousness. So I think we both agree that is an interesting case. For one thing, let's look for some video footage of what actually happened in the park that night. And let's keep our eye on that case. Were there any other controversies percolating that have caught your interest?
I mean, there are a lot of controversies around these actual protests and police responses across the country. But I think a lot of that is dying down now. We'll have to see what interesting things are coming up in the Flynn case. I think in a couple of weeks we had the appellate court having a hearing, or there was the trial court set the hearing on the motion to dismiss coming up in a couple of weeks. So that'll be interesting to follow.
Was that June 11th, the date? I'm going by memory.
I think it was July 6th, actually, but I could be wrong. I'd have to look at it.
Oh, okay. All right. Well, thanks. You are my hero. That is why you are known far and wide as the criminal defense hero, Donald R. Hammond, Esquire.
Well, thank you very much, Jeff. We'll see you next time.
Thanks, Don. Take care.